the jurisdiction of the criminal courts while dealing with the provisions of inquiry and trial. I mean, while going through inquiry and trial, what are the jurisdiction of the criminal courts, and if there is any lack of jurisdiction, whether that will vitiate the proceeding or what will be the effect. That all of that will discuss one by one. So without wasting time, let's just start with the presentation, and then we can also go ahead with discussing all of your doubts. Yes. Wait, I believe I couldn't open the right one. Just bear with me for a while. Before that, if there is any doubt which is left from the previous class, you may ask that, and in between I'll try to find where is my presentation file. Yes, I think I found the file. Let's start with the presentation. I hope I'm audible to you guys. Somebody please respond.
Yes, sir.
Yes.
So in the previous topics, in the previous classes, we had actually discussed the kinds of trials, that is the intricacies of the criminal trial. We probably lacked one thing during the whole discussion of the provisions of CrPC that we did, that we probably did not do them chronologically. But there was a reason I thought of doing that, because I do not think that should be a problem. Just because I did not hold the classes chronologically, you shouldn't be in a position to relink them. And in the process, if you can do that, then that will be actually easier for you, because you know after what comes what provision or what proceeding of the court. So probably we discuss criminal intricacies first, and then we discussed complaint cases. We also discussed FIR. We also discussed investigation. We also discussed the modes of the trial. We also discussed how cognizance is taken. We also discussed how it culminates into a charge sheet, and then how cognizance is taken, how a charge is framed. All of that we discussed. Now we will discuss some of the general provisions of inquiry and trial, which are generally followed by criminal code, which are I time and again I have told that the criminal law is always accused centric. So what happens is that there are a lot of provisions made in CrPC which are just to ensure a fair trial to the accused, because the prosecution is against the accused. Also, the accused is kind of feeling hostile already, because the police brought him to the custody, and then he was put behind bars for a certain time. Then the prosecution is making allegations. He's seeing that the witnesses are coming, and prosecution is trying to influence the witness, and also trying that there is the witness deposes before the court. So in that way, the accused may feel that there will not be a justice. So there have been many safeguards made in CrPC to ensure that the accused does not feel that way, and he feels that the principle of natural justice are followed. The principles that we'll discuss throughout this chapter are nothing but in some way the representation of the principles of natural justice, or an extended version of it, if not a narrower interpretation. So let's start with section 300 of CrPC, which talks about the principle of auto face acquit and auto face convict. That means the principle of double jeopardy, which says that a person, if he has been uh, convicted, tried by a competent court, and he has been convicted or acquitted, then if that particular conviction or acquittal is in force, then he cannot be tried again for the same offense. That is the general principle. So the requirements, as I laid down, are these four: that the person once tried for an offense, and he should be tried by what? A competent court. What do you mean by a competent court? That a court having the power to actually dispose with the case. So, for example, in a case, if a court who was not competent to try a 304B case, presuming that it's a 304A, and hence it is a magistrate tribal case, but actually it was a 304B case, so it's a sessions tribal case. Just because of this clerical error, or perhaps the typographical error, he presumed that probably he was competent to try, and he tried of the case, and he convicted or acquitted the same. That will not be a bar under section 300, because the court here was not competent. So the requirement, one important requirement here, is that the court should be a competent court. We all know it, and as we know that these are in line with the principle of res judicata. So there is a principle of constructive res judicata. If all of us can remember, there is a principle of constructive res judicata, which says that if there is any claim that he could have made but he did not make, in that way also it is hit by constructive res judicata. In this similar way, there is a provision here that if any offense could have been added under section 221, 221 part 1, and they were not added, then also they will be hit by constructive atrophious acquit and atrophious convict principle. That means a constructive interpretation will be given to it. That means even if they were not charged, still then it will be presumed that if they were charged and that has been resulted in a uh, good conviction or good acquittal, as the case. Of course, there are many exceptions to this rule. That is, if the same is the same are a part of 220 clause 1, actually, if that is coming into picture, then in that case it will not be hit. And if it is of same transaction but they are giving rise to different offenses, then in that case the the res judicata principle will not come, and hence even though it is arising on the basis of same facts, just because there are different offenses, they will not be hit by the section 300, and the accused can be tried once again. There is another exception which says that if the act and the consequence are at different time frames. For example, that while the first trial was being held, the fact of A stabbing B was known to the court. So basically, A stabbed B, and there is a trial for the offense of section 325, because the accused was, though grievously injured, still he was not for some reason 307 was not charged, or and it was obviously not resulted in a death. So that's why he was charged with 325 and it was being tried. In that case, the consequence of he dying later, if it happens later, that means if the victim succumbs to that injury and he dies later, so that culminates into a murder or a culpable homicide, as the case may be. In that case, if there are different time frames and the court could not know that it could have the consequence can arise, and the consequence was not in the knowledge of the court. In that case, a fresh trial can also be given. That is an exception again. Another exception is that if the earlier court was not competent to try the later form charge.
Oh,
For example,
liquid.
for example, if the offense, the first offense alleged is section 379, and the that later turned into, for example, 395, or 39, or let's not go that far. Probably say 379 will never turn into 395, but yes, it can turn to robbery. So 379 was being tried by a court of judicial magistrate second class, and because theft can be tried by judicial magistrate second class, it is any magistrate tribal case. So if it was being tried and it later turned to robbery, so that which is triable by magistrate of first class, so JMSC cannot possibly try it. So in that case, if it turns to robbery, then in that case also the later form charge can be tried once again. Next exception is that a person discharged under section 258 can also be tried if there is a permission of the court who has discharged, or any higher court from the court that has discharged the accused. In that case also there can be a fresh trial. But the ordinary rule is that a person once discharged, he shall not be tried again. Of course, we all know that discharge of the accused is not acquittal, and hence he is being tried here. And also, dismissal of complaint is not an acquittal as well. Hence, it will also not be hit by section 300. So next is private persons. My bad that I have not properly done the presentation, prepared the presentation, because I was in hurry and I had a busy week. Anyway, private persons, whether allowed to engage counsels, that is section 301. Probably in the previous class, there was a doubt of someone that whether a private person can engage a counsel and whether he can submit before the court. The answer is, strictly speaking, he cannot submit before the court except submitting a written argument after the evidence is closed. He can, of course, assist the PP or the APP, and only person who is allowed to appear in a criminal case from the side of prosecution is a PP or APP, as the case may be. And a private person can instruct a pleader, but he will only assist the PP or APP. So in Shiv Kumar versus Hukum Chand, it was made clear that role is that of the junior counsel. It is a 1999 case. I remember one incident when there was a dispute in my court regarding this role is that of the junior counsel. So the PP, one of the PP present in my court, actually made this following observation, which has been held by Honorable Supreme Court, that the role of the victim's counsel is that of a junior counsel. So the victim's counsel here was a very senior counsel, so he felt offended and he objected to same. And but then I had to intervene and probably tell him that it is, when it is saying that the role is that of a junior counsel, it does not mean that you become junior to him. The role here that you are playing is that of a junior counsel, as held by Supreme Court. Though I would not strictly agree to this view, because the role here is to assist him, not to be a junior counsel per se. But then yes, this is a good observation in the sense that you will only be allowed to assist. So that is the role of a private pleader. Now coming to section 302, that is who can conduct prosecution. So there are two categories of persons who are allowed to conduct prosecution. First is the Advocate General, or the government advocate, or the public prosecutor, or the additional assistant or additional public prosecutor. They can conduct. So this is the category of prosecution. and then court can also allow any other person not below the rank of an inspector to conduct prosecution. So any person not below the rank of an inspector can also be allowed to conduct the prosecution if the court permits. But the exception here is that the person who has conducted the investigation, that is the IO, that is the investigating officer, he should not be conducting the prosecution. The reason you all know, the reason is that the principle of natural justice has to be followed. So you cannot be the judge, or in that case, in this case, the prosecutor of your own case, because this is your case that you brought from scratch and you prepared a case. Now you submitted to the court. You submitted the charge sheet on the basis of which a cognizance was taken. Now, if you will argue the case and you will examine the witness, that will not be the right thing to do. That's why not the IO. Now coming to the right of legal counsel and free legal aid, section 303 and 304, it says that the accused has a right to be defended by a pleader of his choice, which is in conformity with the fundamental right under Article 22, Clause 1 of the Constitution, as held in R.D. Saxena versus Balaram. Yes, another important thing is that it also includes, this right also includes that the accused can change an advocate whenever necessary. So there can be a case when many times we see that the advocate does not give consent, and just to obtain the consent, the accused cannot give another, or cannot give it to the another advocate, or cannot engage another advocate. This is a wrong proposition. The accused has always the right to change the advocate whenever he wants. Whenever he wants to, if he feels that there is no proper conduct of the advocate, or whatever may be the reason. In State versus Shovaram 1966, it was held that it also includes the right to change an advocate. Also, another thing is that in court of sessions, if there is no sufficient means of an accused to engage a pleader, then at the expense of the state, a pleader can be engaged, and he shall take care of the proceeding. But the states, of course, can allow other trials to be conducted by state defense councils, as the case may be. So, as far as I know, in Odisha, all kinds of trial, state defense councils have to be engaged mandatorily, and they are a must or a mandatory provision as enumerated under section 303, 304. This is also a constitutional mandate, and the duty of the court is to ensure that the accused is represented by a counsel or a pleader, as held in Muhammad Hussain versus State 2012 case. Now coming to section 305, which talks about the representative on behalf of the corporation or society as an accused. It is not an important provision, so let's not discuss that. Now coming to the general provision which deals with the fact that whether any influence, promise, threat, or otherwise can be given to the accused in order to induce a disclosure from him. So we all know that police cannot induce promise or threat or otherwise to induce any disclosure while he is investigating. But whether during trial, because this is the final stage of the criminal justice administration system, so whether if at this stage there is any chance that the accused is the only person who knows the crime, because there are crimes which nobody sees. So crime is a crime because of its secrecy. So because of the secret factor, it is being tried. So there can be many cases, for example, closed door offenses like domestic violences or anything where there is no, or dowry death case, or any such case where the victim is dead, all the people who can actually depose, they have not seen, or there is no eyewitness. In that case, the accused is the only person competent. So whether an influence, promise, or threat or otherwise can be given to the co-accused in order to make a disclosure, so that the trial can reach a valid conclusion. 316 actually denies that. That 316 says that no influence can be given, or promise can be made, or threat to be given, or any other promise or any such thing can be given to the accused in order to make sure that he discloses something about the case. But there is an exception. There is an exception. The exception here is that the principle of pardon to an accomplice that has been enumerated under section 306 to 308. Pardon, as it suggests, it means that to absolve from the guilt. That means it is not just letting go for now, but letting go permanently. So the object here is to obtain evidence of any person supposed to have been directly or indirectly concerned to an offense in serious offenses by allowing the pardon. So whether when the question arose that whether any such inducement or otherwise can be done, the answer would be yes, if there is a pardon promised to the accomplished under section 306 to 308, then in that case it is allowed. So here it is actually a deviation from the normal rule that the accused should not be induced or promised or made a threat or influenced in order to depose either against himself or against his co-accused. So at what stage it will be allowed or it will be done? That if it is being tried by a CJM or a metropolitan magistrate, that then at any stage it can be given. The tender of pardon can be done. If by a judicial magistrate first class, then during inquiry or trial it will be given. And if by a sessions court, then after commitment, but before judgment at any stage, this tender of pardon can be given. In which cases these are to be given? In cases exclusively triable by court of sessions and an offense which is punishable maximum with 7 years or upwards. In these cases, it will be tendered. Condition here is that full and true disclosure of the whole of the circumstance within his knowledge relating to offense. So full and true disclosure means he should disclose all of it, whether he is a principal, whether he is an abettor, whether he has committed the offense, whether he has not committed the offense, whatever is the circumstance, he will simply put forward the truth. That is the only condition that is to be satisfied. But then a question may arise in your mind that how will the court ascertain that this is a full and true disclosure? So in Gyanendra versus State, this was held that the statement of an accomplice in order to entitle him a pardon must be corroborated in material particulars. Because if we give a reading, a cumulative reading of section 133, read with illustration B of section 114, they go on to say that yes, of course, on the sole testimony of an accomplice or a conviction may lie, but the court should be cautious enough and look for a corroboration. So in such case, it is probably prudent to look for the material particulars to be corroborated by the statement of the accomplished before giving him a pardon or tendering him a pardon. The reason being, the co-accused or the accomplice here is actually going against his colleagues or his brothers and actually making a disclosure of the crime. So when we are trusting him, we should actually look for something so conclusive that we should be able to actually ascertain that this is the truth and this is the full and true disclosure of it. And how it is to be done, that the reasons are to be recorded why the tender of pardon is being done. Because of course, in when you are tendering pardon, that means in serious offenses there is no evidence, there is no evidence whatsoever, and that's why you are forced to tender a pardon to reach to a conclusion. In such cases, you have to record reason why you are tendering the pardon, and then whether the same was accepted or not, that you have to record. and then the accomplish will be examined, and then it will be he'll be sent to the competent court for so that the court can take it from there. The effect here of tendering a pardon is that he'll become a witness, so he'll not no longer be an accused, and because his tender was accepted, then he'll be a witness. But till the conclusion of trial, he'll be in custody. Of course, he'll not be an accused, but he'll be in custody because who knows that whether he's making a true and full disclosure of the facts. The consequence of false or misleading disclosure, or if he is willfully concealing anything with the person who has been promised pardon, and he is saying that yes, I'll make a full disclosure of the case, but he is willfully concealing or giving a false or misleading statement, and which is being determined by the PP, then he can be tried with that offense along with the offense for giving false evidence. So, of course, while while actually charging with him with giving false evidence, the sanction of the High Court has to be obtained. Here, one important thing is that statements made by him will be used against him if he is giving false and misleading statements or willfully concealing something. So basically, we tendered him a pardon. He accepted that. If he is giving full and true disclosure, then he'll be completely let go of and he'll be pardoned. But if he is not, then whatever statements he made, for example, he's not making a true disclosure. He said that he's just said that there is a allegation of dacoity, and the accomplice comes and says that I was not doing anything. I was just simply when I was approaching these people, told me that you please please carry this good because this is too heavy, and I just gave them a lift. But then the fact is that he was actually a part of that crime, and he was a part of that dacoit gang. In that case, he is not making a full and true disclosure. So the fact that he carried the goods, it will be used against him. So here, if there will be a trial, and if he is found guilty, then he'll be held responsible. Otherwise, if it is found that he has actually made a true disclosure of the disclosure of everything, then he can be acquitted. Now comes 309, that is adjournment of or postponement of proceedings. So this is a very important provision. Day-to-day trial is the rule. The summary would be that the basic rule is that there will be a day-to-day hearing until all witnesses are examined. But there can be an adjournment, because of course when the CrPC was made, probably they did not foresee the fact that there would be so many cases, or probably when law started, the era was different. There was no such huge number of cases. Now that there are such huge number of cases, the adjournment becomes very crucial. Even though we want to dispose every case as soon as possible, it is not always possible to do that. So if the court, after recording reasons, if it is necessary, then he can allow adjournments. But the ordinary rule demands that there should be a day-to-day hearing. The object behind such day-to-day hearing is that the speedy trial is a requirement of Article 21, because it is actually affecting the right to personal liberty, because the accused is being held in custody without he actually being proven that he is guilty of the offense. So here another thing is that while allowing adjournment, the court can also remand the accused in custody, but it shall not exceed 15 days. So there is an anomaly here, that whether the accused can be remanded in custody till after submission of charge sheet and before taking of cognizance under section 309, whether the magistrate can remand after submission because it is talking about the fact that when a hearing is being done, it should be remanded. That means hearing has already commenced. So that way, whether during inquiry he can be actually remanded. In state of UP versus Lakshmi Verma, it was held that as it is inquiry and as the chapter under which it is being held is nothing but during inquiry or trial. So hence, the magistrate can very well remand, of course not for a period exceeding 15 days, uh, in case of 309. So another provision that has been enumerated here is that the time limit for uh, trial to be completed in rape cases is 2 months from the filing of charge sheet. Another important element in this provision is that if the witness is present and then the adjournment is sought for by any party, then he it shall not be ordinarily adjourned. The general rule is that it will not be ordinarily adjourned, and only after recording reasons it will be adjourned. But here there is another step ahead, because here it is saying that if a witness is present, then special reason is to be given before adjourning the trial without examining him. So the previous provision was that hearing to continue, and only after recording reasons, and if it is necessary, then it can be allowed. The now statement is that if the witness is in court, witness has come before the court, then he shall be examined. But if he is not being examined, then in that case, a special reason is to be given why the case is being adjourned without he being examined. In Pradeep Ram versus State of Jharkhand 2019 Supreme Court, the position was made actually clear, because the Supreme Court actually gave gave the proper course of action, what is to be done, or how it will be held, that whether the remand can be allowed by the uh, court while exercising 309. I'll read out the operative portion. That is, the accused can be remanded under section 167(2) CrPC during investigation till cognizance has not been taken by the court. Second point is that even after taking cognizance, when an accused is subsequently arrested during further investigation, the accused can be remanded under 167(2) CrPC. But the portion that we are concerned with is that when cognizance has been taken and the accused was in custody at the time of taking cognizance, or when inquiry or trial was being held in respect of him, he can be remanded to judicial custody only under section 3092. So the position was actually made clear in this 2019 case. There are many circumstances when adjournments are not to be granted. Such circumstances are just because the accused is saying that I will show cause why this sentence that you are imposing on me shouldn't be imposed. For that, adjournments cannot be allowed. Circumstances which are not beyond the control of the accused, in that cases also adjournments should not be allowed. At the will or request, or just for the whimsical sake of it, adjournment should not be allowed. Pleader engaged in another court, adjournment should not be allowed. Pleader is ill, adjournment should not be allowed. But it has been given in this section that if there is a payment of cost is to be made, that's a valid ground for adjournment. So in various cases, that's been held by Supreme Court what is a valid ground for adjournment and what is not. The test here, or the litmus here, is actually to be decided by the court after recording reasons or special reasons, as the case may be, how it is necessary that the adjournment should be allowed. Then there is another important power given to the court, that what if the witness is present but the accused or the pleader are not present before the court. Sometimes it happens that the defense counsels do not want to actually make they do not come forward for the trial because they think as long as possible it should be deferred so that the accused will be not behind bars, because if there is a clear cut case being made out, they try to delay the trial. In such case, this is a power given to the court that even if they do not come to the court, even if the accused or the pleader do not come to the court, in that case, the court can dispense the examination in chief or cross examination, as the case may be, after recording the statement of the witness if he desires. This is a very important power given to the court to make sure that the fair trial and the speedy trial principle is being followed. Section 310 says that local inspection by magistrate. So it is saying that for properly appreciating evidence, the magistrate can inspect, make a local inspection of any site, and he will record the whatever the observations that he makes, and those observations will make a part of the record. That is a very small and simple provision. Now coming to section 311, which says that power to summon material witnesses and recall of witness. So it says that at any stage means whether during inquiry, trial, as the case may be, the court may summon a person as a witness. Second, what he can do is that he can examine anyone present even though not summoned. So basically, there is a witness, you will summon him, he comes, he can be examined. There is a person present in the court, but he is not a summoned witness, but the court thinks that he knows something about the case, then he can also be examined. Or he can also recall, the court can also recall and re-examine any person already examined. So both the categories in A and B, if they are already examined, those can also be recalled and re-examined. This is both a suo motu power of the court, and also it can be applied to by any party concerned. But here the mandatory thing that has to be done, that where the court shall allow recall of a witness, that if the evidence is essential to reach the just decision of the case, and in that case recall and re-examination of the person should be allowed. But at his discretion the court may allow, but if it is essential to the just decision of the case, then on application of the party or suo motu as the case may be, it should be allowed. Section 311A says that it can direct for obtaining a specimen signature of an arrested person. Section 312 says that the court can order payment of expenses of complainant and witnesses. These are not that much important. So another thing that we should know, that is that a court witness, if the witness is being called by court, then who should be having the power to cross-examine? The answer would be both parties, that is the prosecution and the defense, both of them can cross-examine the witness if that's a court witness. So this section 311 read with 165 Indian Evidence Act, they give wide power to the court, and the object here is that the whole truth shall be brought before the court, as it is the final stage of the trial, and before that there is no opportunity before the court to make any amends to the decision. So in Shailendra versus State, it was held that if any material witness is left out by the prosecution, then the court can exercise the power vested under this section. Now coming to section 313, that is during inquiry or trial, if not if, so basically during inquiry or trial, here the examination of the accused is to be done. The purpose here is to enable the accused to personally explain any circumstances appearing against him, so that he will he will be in a position to defend it, and he will. So there are many instances, as I told you. First instance where the accused is to be a met with the fact that these are the implicating grounds, that is at the stage of charge. Then again at accused statement, again he is again confronted with the same. Now of course the case has proceeded to considerable extent. There is also provision of uh, making sure that the accused is after charge again explained. In sessions cases there are twice he's being explained the grounds that are before him. So there are many stages where the accused has been enabled to know what are the cases or circumstances that are appearing against him. This is another such provision, and it is a mandatory provision in the sense that if the circumstances which are appearing against him, if they are not put to the accused, then they should not, or they cannot be in fact used against him, as held in Ganesh versus State. So before, so for example, PW1 or prosecution's witness 1, 2, 3, 4, they come before the court and they say that yes, this person is the person who came to our house. He actually started thrashing us, and then misbehaved with my wife, or whatever the case may be. But if those circumstances, whatever the evidences arose, if they are not explained to the accused, then they cannot be used against him. So they should be put to the accused. And in fact, if they are not put, then conviction can be set aside on the basis of that. It was held in Shuvas versus State 2002. So the provision, what does it say? That there are two provisions here. One is may provision and another is shall provision. So at any stage the court may, but after the prosecution evidence is closed and before defense, the court shall. So at two stages court may ask, court will ask. One is in the may provision. That means at any stage without previous warning, the court can generally put any question to the accused. But after the prosecution evidence is closed, but before the defense begins, the court will, or the court shall question him generally regarding the circumstances that are brought against him or the evidences that are brought against him. Here it is, we have to know that in summons case, the accused statement somehow can be dispensed with. In oath, as oath is not administered here, so we have to know that it is not a substantive piece of evidence. So on the basis of an accused statement, if a conviction is made solely on the basis of accused statement and there was no other evidence, but still if you make a conviction, it will not be considered a valid conviction, as held in Devendra versus Gunde. Here another thing we know that yes, deposing before a court, and if you depose it falsely, then it is an offense. But in accused statement, if you depose anything falsely or refuse to answer, then there is no punishment. But one thing is that adverse inference can be drawn against you. Though such answers can be taken into consideration and put as evidence in that case or any other, if it tends to show that he has committed. But we have to know that though refusing to answer or giving false answer entitles no punishment, but if he is making any true answer, or if he is accepting, or if he is making a confession in that accused statement, then that can be used as evidence if it is showing that he has committed that offense. The court, while actually preparing that questions, those will be put to the accused, can seek help of the prosecution as well as the defense. Also, we have to know that the accused may file a written statement instead of answering them orally. So a filing of written statement shall be a sufficient compliance of the provision under this section. Another thing is that the statement of co-accused cannot, or of course should not also be used against another accused, because if it is like that, then always the blaming of the shift of blames will be happening. Court's duty here is to consider the part which seems true and discard falsehood, or accept it wholly, or he can also reject it. There have been divergent views, but the uh, most accepted view is that even though there is a false answer, and if it can be separated from the true answers that have been given in an accused statement, such true answers should be accepted, but false answers should be discarded. But the practice, let me tell you, that is that whatever the accused statement, in the accused statement, there is always false answers that comes, because if you ask someone that whether you have committed murder, the answer would be no, unless he's a saint, which of course he is not, because he committed a murder in the first place. You will always say that no, I did not commit the murder. So the purpose of accused statement is, uh, though not a mere formality, I believe that it is always somehow not useful for the case. But then yes, it is useful for the defense, because if the accused answers it in a manner that, if somebody from you wants to practice, there is a trick that you should know. In accused statement, you make sure that your accused answers the case, not in evasive denial should not be there. So you deny the allegation, but then make a statement, so that you can use it, you can take it from there and use it as a defense. So basically, if the accused is asked, or if there is a question put to the accused that whether you have committed murder, so instead of replying no, you should reply, no, this is a false case. They are trying to malign my image because I rejected their offer to contract, or whatever as the case may be. From that, you can build up your prosecution case. So accused statement, though not really useful for the prosecution, if somebody wants to become a devil's lawyer, uh, any one of you, you should know that an accused statement is the building block of a defense evidence. So if you use the accused statement properly, then only you can build your defense, and then only you can warrant an acquittal for your client. uh, though I shouldn't be telling you all of this, there is a chance that you'll use it in my court. But then, as this is a discussion and this for academic purpose, I am just making this statement that you may employ this provision in courts in order to make sure that your accused is in a better place. So in Usha Pillai, so that that will I'll ask this question, in fact, that whether if 205 and 317 is dispensed with, in that case, whether an accused statement is a mandatory thing to do, or whether an accused statement is still mandatory if 205 and 317 is dispensed. We'll discuss it at the end of the class if none of you answers the question. Now coming to section 314, that which is arguments on behalf of the prosecution. So which says that after prosecution evidence is closed, then the prosecution may submit orally or through a written memorandum its argument, and the argument, of course, will be subject to regulation of the court. Regulation of the court here means that if it is otherwise vexatious, or just lengthy enough and not serving any purpose, then the court can regulate it. But of course, no adjournment for this should be given unless reasons are to be recorded and it is absolutely necessary. Then only an adjournment can be given to the prosecution to make an argument before the court. Now coming to 315, whether accused is a competent witness. Yes, he is a competent witness and he can give evidence on oath if he requests in writing. So for the litigation aspirants, the devil's lawyer, as I call it, if you want to start building a case, build it from accused statement, then go to 315, support it with defense evidence, and then you make your case. It's very sad that I do not see much use of accused statement, 315, and the defense witness, and the defense actually relies more on the lacunae of the prosecution case rather than building a case for themselves, which shouldn't be the case. I believe when equal opportunity is being made to the both the parties, like in civil cases, when a plaintiff is making the evidence, the defendant also brings his evidence. So why not you make a case from the scratch, like the police made a case from the scratch? So I believe that for prosecution, FIR is the building block which started the case, and then from there they took it through the process of investigation and charge sheet, and then they with evidence they substantiated it. Likewise, if in accused statement you make a case and then substantiate with 315 accused with evidence, and then take it from there with defense evidence. Of course, it is not mandatorily required. That's why most of the people do not, as held in Kashiram versus State. So section 317, coming to 317, which is talking about proceeding in absence of the accused, which says that at any stage, if court is of the opinion that personal attendance of the accused is not necessary or disturbs the court, then in that case, the personal attendance can be dispensed with, and after recording reasons in the interest of justice, the personal attendance of the accused can be dispensed with if it is not necessary or the accused is actually vehemently disturbing the court. In that case, the personal attendance can be dispensed with. But of course, this court can subsequently direct him that he will appear, and if no pleader is there and personal attendance of the accused is absolutely necessary, can also allow for an adjournment, or they can split up the record and just hear the case of the accused who is present and allow time so that the accused who is not present, he can come later and his case can be heard later. Section 318 says that the accused is not understanding the proceeding of the case, then still then the court can go ahead with the trial, and if he is the only condition here is that he shouldn't be of unsound mind, because if he is of unsound mind, then there is a separate chapter dealing with that. But if he is not of unsound mind, then if he is still not understanding because he comes from a rustic background, he's a villager and he does not understand, or there is any such reason, then in that case uh, 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 the court can still go ahead with the trial, and if that results in a conviction, then that is sent to the High Court, and the High Court will take it from there. Where what course of action is to be followed, the High Court will decide that. That is given in section 319. Now coming to 319, which says that power to proceed against persons appearing guilty of offence. So this is a very important provision again, which says that during inquiry or trial, if from the evidence, here evidence, what does it mean? Here evidence, what does it mean? Evidence here means that it should be an evidence and not basically from the prima facie perusal of the charge sheet or the case record. So basically there should be a witness which is coming and deposing, and in that, from that evidence during inquiry or trial, it is of the opinion, the court is of the opinion that another person has committed an offense, then that person can be also added in that case. For example, one person had filed a case against Ram and Shyam. Now, while coming to the court, he is deposing that Ram, Shyam, and Lakshman, three of them actually came in bit. So now the third person he is mentioning, he was not originally added in the charge sheet, or he was probably deleted from the charge sheet under section 169. In that case also, section 319, using 319, he can be added. And if he is not in attendance, then he will be summoned or arrested. And if he is in attendance, then he may be detained till the trial is over. Fresh proceedings will be held in respect of him. That means if there is any witnesses which were already examined, then they will be called again and they will be examined once again, and the witnesses will be, of course, reheard. But you have to know that the accused, though added right now, they'll be presumed to have been retrospectively added. That means it will be presumed that if they were originally accused while at the stage of taking of cognizance. Now comes compounding of offenses, that is section 320. What does it mean by compounding of offenses? That whether compromise can be done in a criminal case, ordinarily speaking. So here, a list of offenses have been given which can be compounded with the permission of the court and without the permission of the court. So basically, there is a list given, list attached, and you have to refer the a list, and you have to know that yes, whether it can be compounded, and if it can be compounded, then who can compound it. It has been mentioned. So you see that, please. And the important provisions here are that if the offense is compoundable, then the abatement and attempt of the same are also compoundable. It's a natural course to follow. Uh, Another provision is that if the person is not competent, that means he's not the person who will compound it is not competent, or he is below 18 years, or he is of unsound mind, or anything as the case may be, then in that case a person competent to contract can be allowed to compound with the permission of the court. Basically, if there is a child in who has actually filed the case, or who is the victim, and he should be compounding it, is not 18, then the father can come up and also compound it with the permission of the court. And another provision is that if the person who should compound it is dead, then the legal representative can also compound it with permission of the court. Another provision is that if it is the case is committed, or it is pending in the appellate court, then in that case the compounding should happen with the leave of the court before which it was committed, or the appellate court, as the case may be. Another provision given here is that High Court can also exercise revision to allow compounding. And previous conviction, if there is a previous conviction of the accused, and by reason of which he is liable to an enhanced punishment, then there is a bar under section 320 which disallows compounding of offenses. Here, compounding shall have an effect of an acquittal only. And in Gulab Das versus State of MP, it has been held that non-compoundable offenses cannot be compounded even if settlement between parties have been done. Now comes section 321, which is withdrawal from prosecution. So here, the PP or APP can withdraw from prosecution generally or in specific before if it is done before framing of charge, then that will be a discharge, and if it is after framing of charge, then that will be acquittal. So PP or APP, they are the prosecution. If they think that there is no case and they do not want to prosecute, then they can withdraw against the whole case or against some offenses to be specific. And if it is done before framing of charge, then that will be discharge, and if it is done after framing of charge, then that will be acquittal. But the proviso here is that if the center is involved, so the offenses are committed against the union, in that case the PP here should be appointed by the center, and he should be permitted by the central government to withdraw from the prosecution. Section 322 says that if the magistrate is of the presumption that he has no jurisdiction to try or commit for trial a particular case, then in that case, or he is of the opinion that it should be tried or committed by some other magistrate of the district, or he is of the opinion that it should be tried by Chief Judicial Magistrate. In that case, he will submit the case to the CJM. That will make that means that is called being make over the case to the CJM, or submit the case to the CJM, and the CJM can then take it from there and deal with it as the case may be. Section 323 talks about commitment after commencement of inquiry trial. We had already discussed 209, in which commitment was done once process was issued and the accused comes and we find that it is exclusively triable by court of session. We can, after supplying the copies under section 207, we can simply commit it to the court of session. But if it is of the this nature that we did not know that it was a court case exclusively triable by court of session, but later on it came out. As I was giving you an example in the previous class, that what happened in my court once was that the uh, I, the general allegation was that uh, the mother and child had actually made this allegation that the house, I mean the landlord is abusing them, and he thrashed the child and all of that. So 323, 294, 506, all of this was allegations. So the case was being tried by a judicial magistrate first class. Then while uh, the fact that it was on the evidence was being taken or the trial was happening, at that stage the child who came to the dock, he made this particular statement that I'll just use the vernacular reference, that whatever he said that ମୁଁ ପାଣି ପାଇଁ ଯାଉଥିଲି, ପାଣି ପାଇଁ ଗଲା ବେଳକୁ ମୋର ଆମ ଘର ଓନର ମତେ ପାଣ କହିଲା, ତୁ ପାଣ ଛୁଆ, ତୁ ମୋ ଘରୁ କେମିତି ପାଣି ନେଇକି ଯାଉଛୁ କହିକି ମତେ ଦିଟା ଚାପଡ଼ା ମାରିଲା. So he made this statement. So when he made a reference of this particular words, so that means an offense under SC/ST Act is being alleged, which is not to be tried by this court. In that case, what will be the course of action allowed before a magistrate? He will simply commit the same under section 323, and uh, before judgment at any stage he can do so, and it will have the effect as if it was committed under section 209. So that is 323. 324, it's not an important provision, we'll not discuss it. Now comes section 325, that is when the magistrate is of the opinion that it can't pass sufficient sentence even after it started the case, hearing the case, then he is of the opinion that he cannot sufficiently punish the criminal or the accused. In that case, what is the course of action open to him? So here, if the magistrate, after hearing evidence, forms opinion that the accused is guilty, so he has heard the evidence, he is of the opinion that the accused is guilty, but he is also of the opinion that there is a requirement of imposing a higher sentence than what magistrate can impose. In such case, the magistrate can forward the same to CJM for punishment. For example, section 394, I believe prescribes punishment which is which is beyond the power of a simple judicial magistrate first class, though it is a magistrate tribal case. So in that case, it should be forwarded to the CJM. After trying, if it is not empowered, he can forward it to the CJM. Now comes and of course CJM has power to examine or recall the witness and pass sentence or order if necessary. So then coming to trial by different magistrates. So basically it happens usually because frequent transfers of judges or magistrates. In that case, we see situations where trial has been actually committed by 2 or 3 or in fact 10-12 judges. What will be the course then? So here the provision says that the successor judge is to continue the trial from the stage where it was left by the predecessor. So general rule is that successor judge will continue the trial from stage left by the predecessor, and when the first judge had heard and recorded the whole or part of the evidence, or he had ceased to exercise jurisdiction because of course his territorial jurisdiction was changed, then in that case the successor judge will hear it. How the territorial jurisdiction change, you may ask. That there are cases where one court's power is divided into 2 courts, and one new court altogether is formed which has few territorial jurisdiction of the original court. then in that case it will cease to have jurisdiction. In such case, the trial may be committed by different courts, and it is very pertinent on the part of the judge to base a conviction or acquittal on the basis of the statements or evidences recorded before. But of course, if he is of the opinion that examination is required again or further examination is required, then of course he can recall and re-examine the witnesses. Section 327 says that the court will be ordinarily open, uh, and general public will have access to the court, but the presiding judge may disallow the access of the general public at any stage if it thinks fit. So generally it will be allowed to a court, but at any stage, if it is of the view that there is any sensitive case being tried and at this stage the public should not be allowed, then in that case the public can be disallowed. But the opposite thing is said by the subsection 2, that says that in rape cases generally the court shall be closed. That means the proceedings shall be held in camera. In camera, that means not it will be photographed. In camera means it will be held inside a closed room. And the judge here, the previous rule was that he will disallow any person. Here he can allow any particular person to attend the court. Publishing or printing of the proceeding when a case is being tried for a rape, that is unlawful. But of course, when court permits it, then it is lawful. And another provision is that the camera trial, as far as possible, should be done by a woman judge. I had also aimed to discuss jurisdiction of the criminal courts, but due to paucity of time, I don't think I can discuss it because I have some other commitments at 7. And I believe that it is important that we should address your doubts. We probably will discuss them along with the things that we'll discuss at the next class. But I believe there should be 5-10 minutes diverted to your doubts, and then probably in the next class we will discuss this. Along with that, we'll discuss. So in the next class, I'll tell you what all will we discuss. That is jurisdiction of the criminal court in inquiry and trial, and then we'll also discuss the manner of recording of evidence, and the commission. The commission will discuss, and then we'll also discuss affidavits, and then we'll also discuss plea bargaining, and then we'll also discuss limitation for taking cognizance, and if possible, we'll try to uh, go to judgment also. So in the next class, we'll discuss all these provisions that I left out today, and along with that, we'll discuss limitation for taking cognizance. We'll also discuss the judgment, and we'll also discuss the plea bargaining provision. So with this, we'll conclude our session and open it for question answer for a very short time. I have just 10 minutes and I'll have to rush. So will as I can the screen be zoomed a little bit? I'm so sorry I couldn't prepare the presentation properly because I was really in short of time and I couldn't afford to do that. Anyway, you please answer. I mean, ask any question. If I can answer, it would be good.
Hello, sir. Good evening, sir.
Yes, good evening, Shivasis. Tell me.
Sir, is there any provision to transfer a criminal case to other jurisdiction at the time of inquiry or trial?
What do you mean?
Means
That
sir,
whether you can transfer the case?
yes, sir. To other jurisdiction I mean to say that if any of the parties
Yes, yes,
that is accused
yes,
or
yes.
victim wants to transfer the case to a particular jurisdiction, is there any
Yes.
provision, sir?
Yes. So basically, the judges are also humans. The principle is that the judges are also humans, so they tend to be biased if there is any, and if there is any element of bias. Basically, you do not know that there is an accused who is your friend. So this has happened with me sometimes, that an accused who is a friend. Uh, so in that case, the judge is bound to transfer the same, and if he tries it on the basis of that, if later it is alleged that he was knowing the accused, or he had some relation with the accused, then that will just give amount to the conclusion that a fair trial was not given. So in that case, it will be always good to transfer the case. And of course, it should be allowed during inquiry or trial. You can also make over the case to the CJM, and the CJM will transfer it to any other magistrate or judge to try the same.
No, sir, actually, my question is that is there any territorial transfer, means territorial transfer from territorial jurisdiction? Means, for an example, if victim is from, means, suppose let's take an example of Jharakula Naik case. Sir. So the crime was committed at Jashpur, but the victim's family is from Mayurbhanj or from a distance area. If they wants to
Okay. In
transfer the
that
case,
case,
sir.
so you're basically saying that with outside the territorial jurisdiction, whether it can be transferred.
Yes, sir.
Yes, it can be transferred. There are provisions in CrPC which says that, I do not remember. There are provisions in CrPC which says that the High Court can transfer within the state. The Sessions Court or District Court can transfer within the district, even though if it is outside of the territorial jurisdiction of the or the local. So FIR was lodged at Baripada, for example, and it can be transferred to Udala or G Udaygiri, as the case may be, because the Sessions Court felt like, or there was some, because it is in the interest of justice. And then the High Court also can do that if there is a question that there is a possibility that you can say that which High Court will do that. The rule is that court the court which had the, I am forgetting the year, but the provision is that the High Court can do, and the Sessions Court can also transfer the case if it is necessary. Somebody has typed something. Yes.
Thank you, sir.
Yes, as Durga Prasad Panda writes, 407, 408. Yes, there are these provisions are there, in by virtue of which the High Court can transfer the case. The Sessions Judge can also transfer the case.
Sir, can accused be discharged in summon cases?
Accused be discharged in
Summon cases?
I believe we had discussed this. Please, if anyone can answer this question. I want anyone else to answer this question, because we had discussed this in the previous class. Please go ahead, anyone. Just unmute yourself and answer the question.
Yes, the accused discharged in summon cases.
Accused can be discharged in summons cases. That is your answer, ma'am. Anyone else has to differ or want to add anything? 252. Yes. If anyone wants to substantiate or change or agree.
Sir, generally in summons cases, the charge need not to be, means generally the substance of accusation is stated to the accused in summons cases. Then the accused,
So
if
basically,
pleads
do you mean
guilty,
to say that
then
if
can be
substantive
convicted or
accusation is
can
to
be
be stated?
acquittal after this.
Yes. So if that means that if substance of accusation is to be stated and a charge need not be framed, whether or not he cannot be discharged. Do you mean that he cannot be discharged?
No, sir. He can be discharged because it's the discretion of the magistrate. He can frame the charge or not. You means you last time you discussed that if it is for the favor of justice, the charge can be framed in summons cases. So if charge
Yes,
can be framed, then the accused can be discharged.
absolutely. There is no bar of charging the accused. So in that case, if you go ahead with the charge, then in that case you can discharge. Generally speaking, even if you do not charge an accused under summons cases, then also you are issuing a summons, right? That summons can be recalled. We had discussed in cases that where it was held that summons can be recalled. In some cases, it is being held that summons should not be once issued; they should not be recalled. But then in some cases, it has been held that summons it's nothing but a mode of discharging the accused because the accused is being brought to picture. So in that case, he can be discharged. Any other question?
Good evening, sir.
Yes.
Sir, I had a question regarding section 313. The clause 1 says that clause 1, subclause A, may at any stage, without previously warning the accused, put such questions to him as the court considers necessary. In subclause B, it says that shall after witnesses for prosecution. So does this
Right.
section make it mandatory for the judge to examine the accused? Because at one place it's saying may at any stage, and in the other one it's saying shall after the witnesses.
Yes. May is an enabling provision, whereas shall, when it is used by the legislature, it only wants one thing, that it shall be mandatorily followed. And failure to do that, though it will not vitiate the trial if it has not resulted in a failure of justice, but then if it has the circumstance, if it has not been put, as we discussed, as it has been held in many cases, if the circumstance or the evidence that has been coming before the court, if they are not put to the accused specifically, and this is a very I have told you that accused statement is not really benefiting anyone, but then the procedure here is just to make sure that the accused is once again hit or once again bombarded with the facts which go against him or the evidences which go against him, so that he will again be given a chance that whether these are the evidences or incriminating materials before me, what is my defense, what is my course of action to make sure that now the racket has been hit by the prosecution to my court. How will I push it back to that? That is the final course of action available before the accused. So if you take that right away from the accused and you do not, because the accused, you are not at we are reading that he will not be generally allowed to inspect the record, so you will not know what are the cases that are made against you. So in that case, if the shall provision is not followed, then that will not be an anomaly only, and that will in fact be an illegality. And in such cases, either the circumstances should not be put, and if it is put and on the basis of that a conviction has been made, then that conviction will not be sustained.
All right.
Shravani Naik, yes, Shravani Naik also answers the question in similar light. That is whether what will be the effect of non-compliance of section 313. As I said, if it is resulting in failure of justice, that means if it is the circumstances which are not put to the accused, they are used, and on the basis of that there has been a conviction which is resulting a failure of justice, then in that case the trial should be vitiated and the conviction will be not sustained. Anyone else has any doubt? We have 3 more minutes.
Sir, sir, can a charge sheet can be modified at later stage? Means my question is that if police find at the time of investigation in another case, finds out that there is some more offense relates to a case against which
If it
he
has,
has already submitted the charge sheet.
do
Sir,
you
can
mean to
it
say
be
that
modified?
whether it has been kept open or it has not been kept open?
No, no, sir. No, means the first case is in trial stage, hala, against which the police has already submitted the charge sheet. But while investigating another case, the police finds that there is certain means the some more offense is means needs to be put in the previous case, means charge sheet of the previous case. Can it be modified at that stage?
We generally call it supplementary charge sheet. So basically, if the police actually later finds, and before conclusion of trial also it finds that there is this case which was not known to us, or this is the offense which has been committed but which was not known to the police, and if it is after maybe in investigation in some other cases it found out, even though it has actually submitted a negative charge sheet or final report as the case may be, it can later also change it, because if now, so in that basis only the cases are reopened. Reopening of cases, you must have heard, how are they reopened? Even if they are closed, even if there are final reports given, still then there is a course of action, because we all know, except in certain cases, in criminal cases generally speaking there is no limitation except in petty cases, and as we will discuss. But in criminal cases, any time it can be brought. So applying that rule, the police is at liberty to, of course, if it was beyond their knowledge, if it was in good faith, then they can definitely come forward with a supplementary charge sheet and they can supply it, even though it was not kept open under section 173(8).
Thank you, sir.
With that, we'll actually end our discussion. Though I know that there could be more questions, and I thought that some of you will ask certain questions, but then there is a paucity of time with me. I'll take your leave. If there is any question, you post them in the group, and I'll try to answer them. And in the next class, we'll discuss certain small topics which will somehow conclude our trial aspect, and then we'll proceed with appeal, reference, revision in another class. So there can be max 3 to 4 class, and we'll try to end our CrPC discussion and then proceed to CPC, which will be in fact a fruitful discussion, I believe, after this. Okay, so if there are any questions, you please post them in the group and I'll take them and I'll answer them. Thank you for a patient hearing. Have a great evening and a great weekend. Bye. Stay safe.
Thank you, sir.